think we've reached the 7 o'clock hour. We want to welcome all of you that have joined us tonight for the Georgia Directives. What exactly do they mean? I am honored to have been invited to introduce our program about Georgia Directives. I'm sure anyone who has entered a hospital, spoken with a physician prior to a procedure, that you and your family members may have been asked, do you have an advance directive? Have you completed a post form? Understanding advance directives can be an intimidating task. In my work with Weinstein Hospice over the past 15 years, people will ask me what types of forms are the most important to have in light of their loved ones aging or facing a terminal illness. It is crucial that when you are faced with a health crisis or medical issues arise for a family member, that we have done everything to honor and protect our loved ones. This has been especially true during COVID times, when a loved one has been alone in the hospital without a family member being able to be present and offer advice and counsel. The advance directive formally conveys an individual's wishes about medical decisions to be made when their decision-making ability may be lost. Having a document that spells out their wishes alleviates the burden on family members to make decisions on their own. My role with Weinstein as a social worker is to engage with our patients and family members during their loved ones' hospice care, to offer emotional support and provide education regarding the end-of-life journey. It becomes evident that without having an advance directive in place, without knowing what their loved one's wishes are, places a family in a position to make decisions that they may not feel comfortable making. This can be incredibly distressing, and often the decisions are left to a distraught loved one. The response I have often heard is, I'm being asked to play God. With advance directives in place, one is able to carry out what it is your loved one wants, and it becomes an incredible gift, not only to the patient, but family as well. We know that advance directives are not always perfect, but it is the best tool we have to provide your family with clarity and confidence that they are making the healthcare decisions that you would want them to make. Again, we welcome you tonight, and I am very pleased to introduce Richard Bressler, who will be moderating our discussion. Richard is a career marketer and community volunteer. He received his bachelor's degree in business management from Tulane University in New Orleans and his master's degree in marketing from Northwestern University in Evanston, Illinois, and has been a marketing and branding executive in New York City and Atlanta, primarily working in the field of healthcare. Since 2012, Richard has been on the board of Weinstein Hospice, serving as its marketing chair. Currently, Richard is the vice chair of the Weinstein Hospice Board Advisors. This is the fourth conversation Zoom webinar that Richard has produced for Weinstein Hospice. I know it will not only be informative, but very interesting. Welcome, Richard.
Thank you, Susan. So welcome to our latest conversation about the Georgia Directives and the Georgia Post Form and what they actually mean. The Georgia Directives were adopted in 2007 to replace the durable power of attorney and the living will. It simplified the form to allow people to decide their final wishes if they can no longer express themselves. The post form is for people who know they are very sick and wish to express their wishes themselves. While the choices allowed are very specific, there is no set of instructions that come with them. What people don't know is what each choice means to them and to the end of their life, specifically which way will they suffer the least and things like that. We will answer these questions and others in our session tonight. To help us do so, we have two local specialists in this field. First, Abbey Flaum, an attorney who advises her clients about end-of-life choices, and Dr. Marc Seltman, a physician who also advises his patients about end-of-life choices. Abbey Flaum is a partner in the family wealth planning group with Cohen, Pollock, Moylan, Turner, and she's a member of the Estate Planning Council and has been named Legal Elite by Georgia Trend. Ms. Flaum received her Bachelor of Arts, summa cum laude, from Arizona State University and her JD from the University of Miami and her Master of Laws in Tax, cum laude, from the University of Alabama. Dr. Marc Seltman is a partner with Personal Care Physicians of Atlanta. He is board certified with the American Board of Internal Medicine and a fellow of the American College of Physicians. He serves as staff physician at both Northside and Emory St. Joe's Hospital of Atlanta. His practice is largely a concierge medicine practice focusing on one-on-one care without the hassle of long wait times. He is known as one of the best doctors in America since 2009. Dr. Seltman received his undergraduate and medical school degrees from Tulane University and completed his residency in internal medicine at Emory University in Atlanta. We're going to start with Abbey, who will share her insight into the Georgia Directives. Marc will comment on the treatment options section, then introduce the post form. After the discussion, we will have some Q&A. So please put your questions in the chat box, but please keep your questions to be general questions only. We are not interested in personal situations. With that, let's turn it over to Abbey.
It doesn't much help if I'm on mute. Okay. So, well, thanks everybody for joining us. I know it seems like a bit of a somber topic, but it's really important to talk about the Georgia Advanced Directive for Healthcare. First, what you should know is that this is a Georgia state form. The Georgia legislature came out with this, like Richard said, in 2007. If you Google it, you'll find this form online. I think it's really important to understand this form. If you check into the hospital, and I don't care if it's for a paper cut or a major surgery, they're going to ask you if you have this form. And if you say no, they might throw it over to you. But without any guidance, it's really difficult to understand this form and how best to fill it out. So what I'd like to do with you tonight is walk through it a little bit. To say the lawyer thing, this is not intended to constitute legal advice, and for legal advice, you should consult with your attorney. But I would say that this is my interpretation of how best to understand this form. And so I think it was Susan that said that this is a gift you give to your family, and that's really true. If you look, and the beginning of page 1 is up there on the screen, at the top of the page, you'd complete your name and date of birth. And then part 1 begins at the bottom of this form. Now, this form is here to serve 2 purposes. Purpose number 1 is it allows you to name a person, we'll call that person an agent for purposes of this form. And your agent is there to make healthcare decisions for you if you can't or you're not willing to. Okay, so maybe you're going to be just fine, but for the time being, someone needs to make healthcare decisions for you. Your agent, named under Part 1, Section 1, is the person that you have selected to make those decisions for you. The other purpose of this form is to serve as your living will, and we'll talk about that. That section of this form deals with the person that makes sort of the big deal decision about whether or not you're going to remain on life support if you're in a really doom and gloom sort of circumstance. Now, when you are naming your healthcare agent, this is something very important to keep in mind. Whoever you name has the ultimate decision-making authority with regard to your health if you can't or won't make your own healthcare decisions. And I'm sort of smiling to myself because when I talk about this with clients, some of them are in the room with their spouse and they'll start joking that their spouse is going to take them off life support if they have a paper cut. This form applies if you cannot or will not make decisions for yourself. So bear that in mind. It is important to name someone that you believe will carry out your healthcare wishes in the way that you would want. So for example, if you are a pull the plug kind of person and you plan to express that in this document, which again, we'll talk about later, then you should choose someone as your agent that you feel is willing to carry out those sorts of preferences and use their judgment to determine that it's time for that. The other thing I will say is that, can you name more than one agent to serve at a time as sort of co-agents? You technically can. Would I advise it? No, I would not. If you name more than two, you can say that they serve by majority. So majority rules determines your health care. If you name two and they don't agree, they're at an impasse, which means you are potentially in limbo. And this comes up a lot in practice when my clients say they want to name their adult children. That can be both a blessing and a curse. Sometimes we wind up doing it because the clients insist. Sometimes we come up with an alternative solution, for which I have many. So keep all of those things in mind when selecting an agent. Now on page 2, in section 2, you have the opportunity to name backups in case the initial person that you've named in section 1 cannot or will not serve as your agent. And all of the rules I just gave you for selecting an agent apply with regard to these backup agents. So keep that in mind. I do like to have at least one backup. Like I said, this is a free form that you can get Googling it online, so you can redo it as often as you like. But just in case something happens to your first agent and you're not quick to update your advanced directive for healthcare right away, best to have a successor in place. Okay. If you want to move ahead to page 3, this is where we really get into making some decisions. And this page applies after your death. And I think it is the most counterintuitive page I've ever seen written. But that's what you get when you put a bunch of lawyers in a room to come up with a simple document. So if you look in section 5, well, first, section 4 talks about the authority of your agent to really act. And that's what we just went over. In section 5, though, this is where we make some decisions. And the reason I think that this section is so counterintuitive is because you're supposed to initial for things that you do not want to allow. So for example, in 5A, when it talks about autopsy, if you're okay with the idea of autopsy and you want to leave the decision about whether or not it's going to happen up to your healthcare agent, then you should leave that blank. If you leave it blank, you're not saying, do an autopsy on my body after I die. You're just saying my healthcare agent can ask for one if they think it's appropriate. On the other hand, if you are adamantly opposed to the idea of autopsy and don't want it done unless required by law, then you should initial that blank to say that. Okay, counterintuitive. The same is true for organ donation in section B. And there's 2 types here. The first is organ donation to a medical study program. And the second is organ donation in what I would think of as the more traditional sense, donating your organs to someone who could use them. If you want to leave the decision about the donation of your organs in either instance up to your healthcare agent, you should leave these blanks blank. But if you are against either or both, donation to medical study or donation to someone who could use your organs as a recipient, you should initial the ones you do not want to allow. Oftentimes I'll have clients that are okay with donating their organs to a recipient, but not necessarily okay with medical study. Some people are adamantly opposed to both. Whatever you're opposed to, you should initial. If you are fine either way, you leave it blank, and your healthcare agent can decide. In section C, if you have a properly drawn will, that would generally take care of naming who is going to take care of the final disposition of your body. But if you don't, or you're unsure, you can initial the blank under section C, and you can list in the little blanks that say name, address, and telephone number, the person who you'd like to be in charge of this. And just below that, you should initial buried or cremated. This time though, it's the one you want. Initial beside the one you want and list out all of the contact information for the person you want carrying that out. That part's simple enough. Okay, moving on to the next page. Well, the next page I think we'll come back to just at the end. So we'll skip ahead to page 5. Okay. Yep. Keep going. Keep going. All right, that's it. So in section 8, that is a place for any additional statements you might have relating to your own healthcare or treatment preferences. Many people leave this blank. Sometimes people will write allergies in this section in case your healthcare agent may be unaware. Sometimes people will include religious preferences relating to the care of their body in this section. I've had some clients write some funny things about former spouses and what they cannot do with regard to healthcare preferences. But I'll say the overwhelming majority of clients leave this blank. It is totally dependent upon what you want. I have a lot of clients inclined to write, give me pain medicine if I'm in a bad state. But really that's addressed in the section that we're going to come back to in just a little bit. Section 9, in case of pregnancy. So in the state of Georgia, if you are pregnant and you express your preferences to be unplugged in the living will section of this document, the state of Georgia will not honor that preference. Now, if you are pregnant and if you have indicated that you want to be removed from life support in that really doom and gloom sort of situation, and if the fetus is not viable, meaning that there's little to no chance that that fetus will make it in the outside world, and if you initial this blank, what you are saying is, if I am pregnant, if I'm incapacitated, terminal, and or permanently vegetative, that fetus is not viable, please honor my wishes and allow my agent to remove me from life support pursuant to the terms of this form. Okay. Section 10 has to do with guardianship, and this is not guardianship for your children or your grandchildren. This is guardianship for you. If a court would need to appoint someone to be legally responsible for your support, safety, or welfare, because you can't be legally responsible for those things, then this is your chance to nominate the person that you would want to be appointed to serve as your guardian. If you nominate someone that is different than your healthcare agent, your healthcare agent's choices will have priority over this person with regard to healthcare decisions. Typically, though, most of my clients want to initial beside paragraph A, which indicates that they named the same person they've nominated as an agent to serve as their guardian. On the last page of this document, what this basically says is that this document is effective until you replace it or you pass away. But you'll see at the bottom of that bolded language, there's a little blank, and you can initial that blank and complete the dates if you only want this healthcare directive to be valid for a certain period of time. For example, if you just want to appoint someone because you're going in for a surgery or something like that, you could do that. I do recommend completing this, not minimizing the period of time. And then if you want to replace it, after you're well, I think that would be preferable. To go back to, let's see, page 4. This is what I would call the star of the show, the big deal sort of section of this whole document. And this is the living will section. There you go. Out of all of the sections to be confusingly written, it hurts me that this one is so confusingly written. Section 6 of this part 2, even the sectioning is a little bit confusing, but section 6 are the conditions under which your treatment preference that you select in section 7 will apply. And there's 2 conditions. One is a terminal condition, meaning that your death will result in a relatively short period of time, and in reasonable medical judgment, that condition is irreversible and incurable. The second condition is a state of what's judged to be permanent unconsciousness, which is irreversible and incurable in reasonable medical judgment. Now, sometimes people hear these things and they say, well, what if I have terminal cancer, but I'm okay for now? Well, if you are okay for now, then this document doesn't apply. You can make your own healthcare decisions. And even if you can't make your own healthcare decisions, but it isn't the end, this document isn't really going to apply. This is when I say doom and gloom, this is doom and gloom. The doctors have come to your healthcare agent and they have said, we think this is it. And that is the time to carry out the preferences of the person completing this document, what we call the principal. If you initial both blanks in section 6 and A in section 7, what you are saying is, if you are terminal and or permanently vegetative, you want your healthcare agent to do everything they can to keep you alive. You want machines, you want medications, you want anything that they think is going to keep you alive, you are staying here. That is what those 3 choices together would mean. If you choose both blanks in section 6, which I typically see, and C in section 7, what you are saying is, don't keep you alive. However, there are certain exceptions that you can choose to that, certain measures that you might want your agent to take, which could prolong your life. And I think Marc will touch on certain misconceptions about nutrition by fluid, nutrition by mouth and fluids by mouth and things like that, and what it does and does not mean for pain associated with dying. If you choose both blanks in section 6 and be like boy, what you are saying is, if you are terminal, incapacitated, and or you are permanently vegetative, your agent should let you go, but keep you comfortable. They shouldn't give you anything that's going to keep you alive without curing you, except for pain medication. You might remember before when we talked about additional preferences, I mentioned that a lot of my clients say, give me pain medication. That is covered if you choose be like boy in this section. If you don't choose that, then it may not be covered, and it may be something that you want to address in section 8, but talk with your attorney about how to best address your additional concerns in section 8 so that it's clear to everyone involved. I think that really talks about, or really speaks to how we look at this from the legal end of things. What this document is not It is an advanced directive for healthcare. It is not what people commonly refer to as a DNR or a POLST, a physician's order for life-sustaining treatment. And I think Marc is now going to talk to you about that particular document.
Thank you, Abby. Thank you, Abby. That was a great summary. So the first thing, before we go into the POLST, I want to clarify, there's a lot of abbreviations that are made that I think people don't understand. CPR, DNR, the POLST. And I think it's important that people understand what those really mean before we go into this. So when we talk about CPR, which stands for cardiopulmonary resuscitation, that is when someone will attempt to bring your pulse back or your breathing back by compressing your chest with CPR. You could get shocked with a machine, and you could be intubated where they could put a tube in your throat to try to get you to breathe with oxygen. So it's a very aggressive and a very invasive procedure, but that is a method of resuscitation. DNR means do not resuscitate, and that basically means you do not want to have resuscitation and you will not get the CPR. So it's important that you understand those differences. And what Abby was talking about, to finish up on the advanced directives, I think there's also a misconception when you look at the bottom of the advanced directives, talking about what if I can't take nutrition by mouth? What if I can't take fluids? I think people think that it is painful to not be given nutrition, or it's painful not to be given intravenous fluids. So if you're at the end of your life, I've got to say, if you're going to take one pearl away from my little discussion today, is that it is clearly not painful to not be fed artificially. It is not painful to not be given IV fluids. People will just slowly, their kidneys will fail, and it'll just be a quiet death, and it is not painful at all. And I think that's really important. And it's even been discussed that, what you're holding back food, that's the sustenance of life. How could you do that to somebody? Again, it is not painful to go through that. So I think whenever you're filling out these forms, going through that, please keep that in mind. So let's just go to the top of the POLST again. So let me explain to you again. The POLST stands for Physician Orders for Life-Sustaining Treatment. So how is this different than what Abby just discussed at the advanced directives? So this POLST form, which also, by the way, you can go online and print this form up. Anybody can get it. Every state's a little bit different. This is the one you're seeing is the Georgia one. Some states call it portable medical orders instead of physician orders, portable medical orders. And this is not for the average healthy person who wants to do their advanced directives with their attorney. This is a form really just between a patient and their physician. It is signed by the patient and their physician, and it truly is medical orders. And the people that need to consider doing a POLST form are people who are somewhere near the end of their life, or are not going to be able to communicate what they may want when it comes down to the end of their life. So people that have, let's say, advanced terminal cancer, people with chronic lung disease like emphysema, chronic heart disease, chronic heart failure, dementia, or any progressive neurologic disease. So these are the types of disease you want to think about and discuss with your physician whether you should have a POLST form filled out. And what do you do with these POLST forms? Before I go through it in detail, this is something that should be, again, you'll have it signed by your doctor. You'll go through it with your doctor. And it's an order that should be put in bright pink or bright orange. And it should be put on your refrigerator. There should be a copy in your wallet. Your family should have copies. If you're at home, you have a terminal disease and you've filled one of these out that you don't want to be resuscitated. If God forbid you're at home and something happens, you fall, pass out, hit your head, you're unconscious, and the ambulance is called and the ambulance arrives at your house. If you don't have one of these pulse forms easily seen on the refrigerator, or there's not a family member around to say you have it, they will attempt CPR, which again is chest compressions, possibly shocking you. Again, this is if you can't respond, obviously, possibly shocking you, possibly intubating you, because they will have no idea. That's their duty, to try and resuscitate you and then try to get you to the hospital. So it's very important that this form is easily seen in a very obvious place. We talk about putting on the refrigerator, like I said, in a bright color. So let's go through this form. And again, remember, this is really just physician orders. This is not, this is not potential legal document. It's a document between you and your physician. So the top part, which is your code status. So if you have no pulse and not breathing, again, the situation, like I just mentioned, if you're passed out and have no pulse and not breathing, when someone shows up to resuscitate you, you're going to want to fill out whether you want to allow the natural death to occur, which would be the second box, or you want them to attempt CPR. So that's pretty straightforward, and that's what you're going to check there. The second part were medical interventions. Now, this is when you do have a pulse or breathing. Again, you have a terminal illness, or you're maybe within months or less than that of passing away. You may just not want to do anything and just have comfort measures. And please understand, when we talk about comfort measures, this involves treating your pain. You will not be in pain. So comfort measures do include pain, but you don't want to go to a hospital. And if you'll notice, it says do not transfer to the hospital for any life-sustaining treatment. They'll give you anything, to stop, a wound or help your pain, or anything that they're going to keep you more comfortable, basically. And that's what it's all about, is comfort measures. The second box is you may want some things done. You may want to go to a hospital, maybe to get some intravenous fluids, to treat a fracture, but you don't want to end up going into the intensive care unit. You don't want to go to an intensive care unit, which would require most likely close monitoring, possibly doing CPR if needed, possibly intubating you. But a lot of people just don't want to go into the ICU for acute care, but they may want just medical treatment to just treat something simple. Like I said, it might be IV antibiotics, might be IV fluid, something like that. And the third box would be you basically want a full court press on this section B. It's a full treatment that the ambulance will, the EMTs will do everything possible, CPR, shocking, everything, intubation, and get you to the hospital and do a full court press to try to save your life. The third section is section C, and this is also where it's just added some other things, antibiotics. Again, some people, certainly giving antibiotics are not painful. They can extend life, but some people may want to, again, just let natural death occur and not even use any antibiotics, and that's where you would check the first box, no antibiotics at all. The second box would be you leaving it up to judgment of the physician, whether you want to limit antibiotics. So it could be, let's say it's a urinary tract infection or even pneumonia. You may want some limited antibiotics to try, and that's fine. And the third section is basically do everything possible. If you can prolong my life with antibiotics, please go ahead and do that. Lastly, in section D, this is when we came down to talking about the intravenous fluids and feeding artificially with a tube that would go into your nose, into your stomach, and you'd be artificially fed. So again, on the two sides of the line, you either decide, do you want no artificial treatment at all by tube or IV fluids, or do you want a trial of one or neither or both, or both? So it's a trial of artificial nutrition by tube or a trial period of IV fluid. So you may want to do this for a few days or things like that, and that's where you would check this box. And the third box on both sides basically are do whatever you can to prolong my life as long as you can. And that will include feeding me artificially with a tube, putting an IV in my arm, and giving me IV fluids. And at the very bottom, again, this is where, again, this form has to be signed by you and your physician together, and they can help walk you through it and explain at the time whether, if you have some questions about each box. But basically, so that's the pulse form, and that's all. We can open to some questions maybe, which may come up.
Okay, so please put your questions in the chat box, but we've got a question right now for Abbey, and that is on the counterintuitive questions. Do I have comfort that the hospitals know how to read the answers correctly?
Okay, it's a good question. By the way, aren't Mark and I just a ray of sunshine? But you knew what you were getting yourselves into when you signed up for this tonight. Important stuff. Remember this. If you fill out nothing on the advance directive other than who you want to make decisions for you, then you're in good shape. And what I mean by that is, if you complete preferences and you're worried about how they're going to be interpreted by a hospital, you're worrying about the wrong interpretation. It's the person carrying out your wishes that has to make all of the final decisions. So what I often recommend to clients is, first of all, you should let the person that you've selected as your agent know, and even ask their permission if you have that kind of relationship. That would be preferable. But you should communicate what your real wishes are to them about all of these various matters. Now, if you do name a person, like I said, they can overpower your wishes. If you do not name a healthcare agent and you only select your preferences in this document, then it is up to the medical staff to interpret what you meant by making those selections. For me, I don't think there's any way that I wouldn't choose someone, whether it's a family member, a close personal friend, someone I trust to make those healthcare decisions. To me, that is the most important part of this. And remember, sometimes people say, I don't care what happens, I'll just put that decision on my family. Well, that's exactly what you're doing. So by completing this document, you're really giving a gift to the family, and you're really saying, look, guys, if I'm in a really bad situation, here's what I want. And what I want is okay with me, and I want you to know it.
Okay, and here's a question for Marc. Since you don't know how it's going to go, which form is more important to have? It might be a question for Abbey as well. Which form, Pulse or Georgia Directives?
I mean, I think, there's nothing wrong with having both. If you want to really be clear to make sure things go the way you want. I mean, the forms need to be sending the same message, obviously. So I'm not sure I'd pick one over the other. There's nothing wrong with, again, the Pulse form is something that's going to be made more towards the end of your life when you know you have something terminal or things, you might be medically frail, and you just don't want something bad. If something bad's going to happen, you don't want them to treat you wrong. Whereas your advanced directives are probably something that were done a long time ago. But I mean, I can see Abby's comment, but I mean, there's nothing wrong with having both of them, but they should agree of what you want.
Yeah, everyone should have an advanced directive. There's no reason for everyone. It's free. It's available online. Everyone should have an advanced directive. And something to keep in mind is that when your kids or grandkids turn 18, they should have one too. They're going off to college. They might do some crazy things while they're there. Let them have an advanced directive for healthcare. And like Marc's saying, typically the people that I see completing a Pulse with their physicians, because remember, advanced directive, attorney, Pulse, physician. Typically the people I see doing that are sort of frequent flyers at the doctor's office for a terminal condition.
Okay, a couple questions about out of state. First of all, if someone completes the Georgia forms but then you end up out of state. Is that out of state hospital going to recognize what it is and all of that?
Typically, the answer is yes. Georgia recognizes other state forms, and typically there's that reciprocity.
Okay. And then a question, I guess, back to Marc. How about covering exactly what a DNR is for and how it might differ from what you've covered?
What a DNR is for, I'm not sure.
Why do you call for a DNR? Under what circumstances would you want a DNR?
So again, I think what you're asking is, again, remember, DNR stands for do not resuscitate. Okay, so if you want to make sure that you don't want, this is either, again, this is a decision that you're going to make with your physician, that you don't want to be resuscitated. I'm not sure I understand the question, versus, again, whether you want something else done. And think of the situation, if you can't speak for yourself and something happens and you're found out at your house, this is what you and your physician have decided, the orders that the EMTs, the emergency room doctors are supposed to follow.
I think I know what the question speaks to, because I think, questioner, that you're perhaps thinking that in addition to an advanced directive for healthcare and a POLST, there's another form called a DNR. But in Georgia, the POLST has effectively replaced what we refer to as a DNR. And I think that that's maybe the question you're asking.
Okay.
Okay. If we have other questions, please let's hear them. Give people another couple of minutes to type.
Uplifting stuff.
Yes. If other questions do come up at a later time, you can certainly send an email to Weinstein Hospice and we will get an answer to you. And that information will be shown on the slide for us. But if there are no further questions, I'm going to thank our two. Wait, one more question. In the hospital for surgery or treatment, is it true that a DNR is not really valid? Situation of a hip surgery, and I was told that the DNR is not recognized.
I mean, I would think, and Marc, you correct me if I'm wrong, I mean, the DNR is basically the document, like you said, you're going to post it up on your refrigerator or tape it to the wall so that if the paramedics show up to your house, they're not going to revive you. If you're in the hospital and they're taking you in for surgery, I mean, it's not the sort of situation, I don't think, where you're going to be in a reviving sort of situation as opposed to a maintaining on life support. And maybe that's what they're speaking to, but Marc, maybe you have more color on that.
Yeah, I think, there's a different situation in the hospital, and again, depending on what's happening, but that would certainly, if again, who has told the physician about the DNR? Is that, were you still awake and you've made the decision yourself? If you can't, then the family's gonna have to go back to one of your advanced directives or POLST forms. But no, the DNR in the hospital, that's, a lot of people don't come in, many people don't come into the hospital with the POLST form. Most people, I would say, don't. So they're left with either advanced directives or the patient being able to tell them exactly what they want. But the DNR they talk about in the hospital is definitely valid. And then, again, unless there's a situation where the patient, they didn't feel like was able to make the right, they weren't in the right state of mind to make that decision, then they have to again go back to the family and the legal aspect of the advanced directives. But yeah.
And then another question is, where is the best place to keep each of these documents once you fill them out? So start with Marc on the POLST, and then to ask.
Again, POLST should be your physician will have one. You should have one on your right on your refrigerator on a piece of paper. Should be where your advanced directives are, and a family member should have it. And then just in your wallet, you can make something small in your wallet or take a picture on your phone. I think all those things are positive. You can't have too many of them.
Okay.
Abby, man, that's what it is.
So for the advanced directive, we always say that you should provide it to your personal physician. You should have copies when you're going into the hospital for anything. I recommend that if you feel comfortable doing so, you provide copies of it to the people that you've named. And I know in our practice, we always have it scanned into our system. So there have been instances where a client will contact me at 3 o'clock in the morning and say, my husband just had a stroke. Do you have the advanced directive for healthcare? And we shoot it over. You can have it as a PDF on your phone for no other, if you don't have it to carry around any other way. That's an easy way to pull up.
Okay.
Right.
Any other questions? All right. What should happen when a person has completed an advanced directive, identified their agent, but when they are approaching end of life, the agent does not follow the advanced directive? How should a hospice agency handle this?
How should what?
How should a hospice agency handle this? So from a hospice perspective, how should they?
From a legal perspective, they have to do what the healthcare agent tells them to do. That's what they're going to follow. So that's why I say be real choosy about who you choose, because you want to choose someone that's going to do what you would want them to do.
So even if the form says one thing, and the agent that you've appointed on that same form says something else, it's the agent.
Yep.
Okay. All right. Any other questions? Or are other formats valid in Georgia? So another something.
So here's what I'll say. This form came about in 2007. Before this form, we used to give clients 2 separate documents. One was a healthcare proxy and the other was a living will. And this form was created to simplify and to combine those documents into one. Now, if your documents predate this 2007 form and that's what you have, that would be honored. But I'll tell you that if anyone's ever dealt with bureaucracy in any kind of organization, you'll know that when you go into a hospital, when you go for medical treatment, the people that you encounter are going to be experts in healthcare or experts in hospital administration. At least we hope they are. They're not going to be experts in all the various kinds of forms. So basically what I'm saying is there's no reason not to have this one. So I would just go ahead and have this one. But yes, other forms could be honored. It just might be a little bit more problematic.
I think that's covers our questions. Like I said, if somebody has other questions, there'll be a chance to follow up. And we will send an email to everyone that's on and who registered with a copy of this video, and as well as a chance to ask questions or receive these forms if you like going forward. Cheryl?
All right, thank you, Richard. So we want to conclude our program by thanking everyone that came out to listen. We certainly appreciate our panelists, Dr. Seltman and Ms. Abbey Flaum. Very, very helpful information, even for people like Susan and I have been doing this for a little while. There's always something new you can learn, and we certainly did. And I hope you all got some very helpful information. Again, this awareness series is really about, kind of talking about these hard subjects that might be difficult for the, everyday person that doesn't deal with, these kind of things, every day. Can be hard to broach with your own family and, getting your wishes made known. So thank you so much. Thank you, Richard, for moderating. Thank you so much, Susan. for the introduction. We are certainly here to support the community, so please feel free to check out this webinar as well as our other 3 webinars that were in this awareness series. They are on our website, weinsteinhospice.org. You will also find copies of these documents, the post and the advanced directive, on our website as well as the general internet. So please take some time to look those over. It's never a bad time to look it over, fill it out, because ultimately you want to be able to make your own decisions about your own health care, especially when you can't speak for yourself. So, so stay tuned. We really appreciate your support in coming out, and feel free to view our website for this recorded webinar from this evening, early next week, and have a wonderful evening. Thank you.